Oh, it starts recording anyways. Okay, hi everybody. Welcome to this anti-corruption law program webinar. We just started the webinar officially, so I see all the numbers trickling in of participants who registered. So we're just going to give it a minute for everyone to enter the webinar and we'll get things started. Feel free to say hi in the chat bar and let people know that you're here, and let people know where you're hailing from this morning, this afternoon, wherever you're tuning in from. I've seen that we have people signed up even from as far away as Jakarta with us today. We'll just give things another 2 minutes here to get underway. And the numbers have slowed down, so I think all the early arrivals are now signed in. So hello, everybody. My name is James Cohen. I'm the Executive Director of Transparency International Canada. And to kick things off with this anti-corruption law program seminar, I'm going to hand things over to Joe Weiler, our TI Canada board member and co-administrator chair of the anti-corruption law program. Joe, take it away.
Good morning, everyone, or afternoon, depending on where you are. Happy Halloween. My name's Joe Weiler, and I'm Professor Emeritus at the Peter A. Allard School of Law at the University of British Columbia. And as James mentioned, I'm co-director with my friend and colleague John Ritchie in the anti-corruption law program. And if you're a first-time participant, the program is a joint working partnership between three major organizations in Canada: the Centre for Business Law at Allard, Transparency International Canada, of course, and the Vancouver Anti-Corruption Institute, which is an affiliate of the International Centre for Criminal Law Reform. This is the 33rd session in our program over the 6 years that we've been going, and it's an example of how three organizations with different core competencies but a common mission in fighting corruption, can work together and take collective action to provide top quality continuing professional education in the best ways of fighting corruption. And the way that we do that, as we've done today, is to bring together sort of leading experts in the field to teach each other and to teach us about what we can do about corruption. So this is the second of a 4-part series on the Cullen Commission Report. And initially we were going to have one session on this, but we know that the Cullen Commission, was a major milestone in Canada on anti-money laundering. at 200 witnesses, an 1,800-page report, 101 recommendations. And so it warranted a lot more. And so what we've done, working with our partners, is create a mini course over this period of the fall and into January. And this is the second session. We kicked off on September 19th, where the focus was on what the commission had said with respect to private sector self-regulation in this field. And today, of course, it's beneficial ownership. Next month, on November 22nd, the Vancouver Anti-Corruption Institute will lead a discussion on unidentified wealth orders and the future of civil forfeitures. So in the final session will be in January, January 19th, actually. And the three organizations, we're going to collaborate to organize one where it's about institutional reform. And we know that the Cullen Commission made major recommendations around the creation of an anti-money laundering commissioner within the BC government, dedicated intelligence and investigative unit within the government, a BC financial reporting agency. And so what do they have in mind, and how will that interface with the various touch points in the government of Canada? So a special thanks today for our continuing support for the program by Dr. Carol Liao and her technical team at Allard, Peter German, who's the executive director of the VACI, and James Cohen, of course, who's going to take over in a second. And thanks in advance to our panelists, for taking the time to prepare and to share their insights with us. So now it's my pleasure to turn it over to James Cohen, who's not only organized this series, but is going to moderate. James, over to you, and thank you for everything that you do.
Cheers. Thank you, Joe. Hi, everybody, and welcome to those who have signed in since we started recording. This session is being recorded. It'll be posted online as our other sessions. I see the green line, Joe, around your name. Can people see me as I'm talking? Just kind of flag into the thing. Okay, great. Adam's giving the head nod. Welcome to this session, as Joe said, on the anti-corruption law program that is being coordinated by Transparency International out of the partner organizations, where we'll be talking about beneficial ownership transparency. And just a couple house rules before we get started. The chat is open now. I see it's working for everybody. I thoroughly believe in working with the panelists that we have join our discussions, as we have exceptional experts join us for these sessions who have just as great insight as our panelists oftentimes. But please do not abuse the chat. Please don't spam it. Try and be cordial. Don't try, be cordial, please. And we'll try and integrate comments from the chat into our discussion for our panelists to give feedback on, and we'll try to address as best we can. Sometimes the chats go rather fast and I can't see everything. So if you have a very kind of pressing question you want the panelists to ask, please put it into the Q&A, and I can see the questions more thoroughly in the Q&A as opposed to the ongoing chat. So with that said, we are going to be talking about beneficial ownership transparency in Canada as a result of what was in the Cullen Commission Report. I'm joined today by two exceptional experts I have the joy of working with on an almost daily basis on this subject. First, I'll acknowledge, I don't want to say partner in crime because we're fighting crime, but I'll just acknowledge Sasha Caldera, who is the beneficial ownership campaign manager over at Publish What You Pay Canada. Sasha has been leading on the government outreach on this initiative amongst what we're calling the End Snowwashing Coalition of organizations, Transparency International Canada or Canadians for Tax Fairness, and Sasha's organization, Publish What You Pay Canada. Sasha's been putting in tireless hours to help advance beneficial ownership transparency in Canada. He comes from a background of international development in organizations such as Engineers Without Borders. Sasha, quick hello.
Hi, James. Thanks for having me.
Great. And Sasha's, of course, here in Toronto with me, joining us from the West Coast, where the Cullen Commission happened. We, of course, would want representation there. Is one of our great working partners, Adam Ross. Adam has authored a number of the End Snow Washing Coalition reports, including the most recent report, the Canadian Corporate Data Transparency Index. We couldn't think of a shorter name. We thought we'd just title it what it was. He's also authored the Opacity Report, why criminals love Canadian real estate. Adam is a partner at Templeton Research and has been doing investigative research for some time and writes fantastic reports on why we rely on Adam so much. Adam, hello from you.
Hi, everyone. Nice to be here.
And unfortunately, Myra Martini was unable to join us at the very last second. Myra is the illicit financial flows campaign manager at Transparency International, the secretariat in Berlin. We're hoping Myra all the best health and that she'll be able to catch up with us at another time. You can certainly follow Myra on Twitter and LinkedIn, and TI on LinkedIn for all the kind of global analysis from TI's perspective on beneficial ownership transparency. So with that all said, let's get to the meat of the matter of the day. The Cullen Commission has been, I can't even count how many months now, since the final report was released. It kept getting pushed back, but we finally got a report in the spring, all 1,800 pages. Anybody out there who's read all 1,800 pages or so, feel free to raise your hand and be acknowledged as a pro and get your credit for reading it. I myself have read the sections that particularly pertain to TI Canada's interests, executive summary being only about 30 pages, the summary of the recommendations even less. So there is a lot that you can read through and get the idea of what was said at the end of the Cullen Commission. TI Canada, we were standing witnesses within the Cullen Commission, so we had testimony, ability, and cross-examination capacity within the Cullen Commission. It was a fascinating experience to be part of, but at the end of the day, the recommendations and the report that came out, maybe let's just start with a general overview from our panelists and your thoughts. Adam Ross was part of the Cullen Commission. So maybe Adam, will throw it over to you first for your thoughts as a slight insider with whatever you're comfortable sharing, and the final results of it all.
Sure. So I was involved with kind of the research investigative side of the commission. I was one of a few investigators contracted to support the commission's work. I was not involved on the report drafting in a big way, or drafting the recommendations, but I think I was very pleased with the beneficial ownership recommendations that came out of the report. I think overall the 101 recommendations were thought very appropriate and kind of really push the agenda forward for anti-money laundering and financial crime in Canada. You know, I'm not exactly an arm's length party, having been involved in the process, but yeah, I think you know, it's if the provincial government and other governments in Canada look at this and implement the recommendations, as I hope they will, I think this will really take us forward on fighting financial crime.
Great, thanks, Adam. Sasha, just general thoughts on the Cullen Commission reports, the process, the end results of the report.
For sure. No, thanks so much, James. And yeah, to echo much of what Adam mentioned, a lot of the recommendations in the Cullen Commission are encouraging, with the strongest notes of encouragement on beneficial ownership transparency. As James mentioned, TI Canada was a witness as part of the Cullen Commission for the past 3 years. And our coalition did a lot of work in meeting with government officials, both at the ministerial level and within the bureaucracy inside BC Finance, to make the case for why an interoperable registry needs to be created in Canada, and that was the recommendation of this commission for Canada to create a pan-Canadian publicly accessible registry, and for BC to be part of that framework. So that's incredibly helpful. The other thing that we thought was helpful was removing the fee for searches on the BC Land Ownership Transparency Registry, and also boosting the capacity of the BC Civil Forfeiture Office. We thought those three recommendations will go quite far in advancing the ball on money laundering, or anti-money laundering.
Yeah, indeed. Adam, any thoughts on the BC Land Registry side? I know you've had interactions with the BC Land Registry.
I have a few. I think the main recommendation, aside from removing fees, was essentially to wait for 3 years and have the independent anti-money laundering commissioner, the office that should be set up, review the landowner transparency registry. Once it's kind of up and running and we have a bit more of a sample to work with as far as assessing its effectiveness. I'll touch on a couple of kind of fundamental flaws that I think there are with the current, the way the system was set up now. This is kind of in my personal capacity, not as a former Cullen Commission investigator. Mm-hmm. I think the way that Loader was set up had a fundamental flaw, because there was no benchmarking done to assess which properties had different beneficial owners from their title holders. So the way that it was set up was kind of a proactive model where anyone with disclosure obligations had to come forward and file a report. And because of that, we've seen a really slow trickle of disclosures. I think there was a Globe article in May 2022 that said there were around 46,000 owners and 73,000 properties that had filed. And that's about 3% of titles overall. Now, I suspect there's a lot of owners and a lot of properties that should be reporting but aren't. Maybe that's because they aren't aware of the rules. Maybe that's for some of them that they don't want to follow them. And I've actually found that to be the case on more than a few projects I've worked on this year since the registry's gone live, where I've identified properties that were beneficially owned by somebody, a research subject of mine. They were held by a family member, and there was no Loader filing for them. So I think there's going to be a lot of that. An alternative, and this is something I'd advocated before the registry went live, and I think would have been way more effective, was to do some sort of a census where every title holder in the province submits a form saying that they are the beneficial owner of their property, and if they're not, then they're prompted to submit a Loader registration. And the government does that in BC for the speculation tax, and it takes a minute for most people to fill out. It can be done online. It's very, very smooth. And the vast majority of people just file a negative declaration, essentially. And I think that would have given a benchmark for all the properties in the province, and it would have served to educate people. Most people in the province don't know about the Landowner Transparency Registry. So they'd be a bit confused at the outset, but really the education process could have been very simple, I think, for most people. And I think the other big question around Loader is, it's like most regulation in the area, that it's going to come down to enforcement. We have a very strong track record in Canada of building out kind of top-notch legislation and then not enforcing it. And so we'll need to see whether Loader breaks that pattern. And I think on that note, with the Cullen Commission suggesting that we look at Loader again in a few years, once it's properly up and running, and we have the data that we need to make a fair assessment, was a prudent way of doing things.
Great, thanks, Adam. Some interesting points about, food for thought of when an eventual next registry comes out, of course, being the National Beneficial Ownership Registry. And Sasha, as you pointed out, one of Commissioner Cullen's recommendations is that the BC government work with the federal government on the registry and adapt to it. So for those in the audience, I'm sure we have a very aware audience that there's an announcement that we are meant to get a beneficial ownership national or a federal registry by next year. So Sasha, why don't you walk us through where we currently are as a country and what this recommendation by Commissioner Cullen means about BC coordinating with the federal government?
Absolutely. Canada's progress on beneficial ownership transparency probably started well over a decade ago with with a lot of internal conversations that were had. There was concern that Canadian companies were being compromised, and a lot of illicit funds were flowing through these entities. And this is exacerbating problems that we're seeing today, such as Canada's artificially inflated housing bubble, opioids, and drug traffic, and other types of drug trafficking, weapons trafficking. And there was a lot of resistance, I would say, from the federal government in, I would say, taking a very, very proactive approach on a beneficial ownership registry at that time. And it was mostly because Canada was struggling to understand how much money was being laundered in our country and to what extent is it flowing through these anonymous corporate entities. After the very explosive 2016 Panama Papers leaks and the Paradise Papers leaks, it became known that international law firms were marketing Canada as a place to incorporate in secret to clients who had very, I would say, nefarious motives. And Canada ended up taking action as a first step in 2017. So the federal finance minister at the time, Bill Morneau, met with provinces and territories, and there was an agreement to strengthen beneficial ownership transparency. This agreement was struck in December 2017, and what it was a requirement for all federal corporations to hold beneficial ownership information internally, and then provinces and territories would mirror that requirement. So all provincial incorporated entities would hold a copy of beneficial ownership information as a record at their service address. And so that's sort of where we were at. And then our team, we had I think our coalition started around the end of 2017, and we really made the case as to why this first step is good, but Canada needs to go much further and create a national registry and make it interoperable. And as some of the product I mentioned earlier kind of grew, to a level of urgency in the country, specifically with opioids and Canada's housing bubble, things became quite urgent, particularly when Russia invaded Ukraine this past February. And Canada's Minister of Finance made a very strong statement, and in Budget 2022, Canada made a commitment for a publicly accessible registry at the federal level, but on an accelerated timeline for it to be implemented in 2023, and to also work with willing provinces and territories to create an interoperable register, and to also use verified data. So this was a very, very strong commitment. So between the period of 2017 to now, we've seen almost all provinces and territories make commitments to phase one of that original beneficial ownership agreement, and many provinces are on standby to see where the federal government is at with respect to implementing a national register. And as a second step, and as an awaiting step, we're hoping that the federal government strikes an agreement with provinces and territories for an interoperable register, and provinces agree to that. And provinces are supportive of that initiative.
You figure 3 years of this, I'd remember to unmute myself. So Sasha, the Cullen Commission report says that BC should work with the federal government. We haven't heard anything. Any thoughts, any speculation on what's the state of play in BC? If anybody's from the BC government and wants to chime in on the chat, feel free to do so. But Sasha, what are your thoughts?
For sure, I think it's a no-brainer for BC to be part of a pan-Canadian framework. BC was an early adopter with respect to the beneficial ownership registry in Canada, and it makes sense for the British Columbia government to cooperate with the feds simply because it reduces the burden on the BC government in creating a separate corporate beneficial ownership registry, and it could simply plug into the federal model. BC has one of the largest amount of incorporations in the country, and would be an excellent role model for other provinces, particularly smaller provinces, to get on board with this initiative.
Mm-hmm. And I think with the new premier at the helm, David Eby, now that's I was about to say domestic, but we're all domestic politics. But BC politics are hopefully settling down. I definitely think that we're hoping one of the first announcements from the Minister of Finance will be that they're looking to partner with the federal government. As you said, Sasha, a lot of this is based on Canada's reputation as an easy place to store dirty money, or snow wash, as we've seen. Adam, you authored another report for us earlier this year called Snow Washing Inc., where we looked at just how much these intermediaries are marketing Canada overseas. And indeed, at the federal level, we've seen Trudeau in 2019 acknowledge money laundering as a national issue. Earlier this year, not just Canada, but a number of Western countries, when they were trying to implement their sanctions on Russia, and were all of a sudden scrambling to realize that it was very difficult to implement these sanctions because we don't really know what is owned by sanctioned individuals. And just today, I caught on Twitter, Prime Minister Trudeau was at a rally for Iran and said in a statement, I'm paraphrasing here, I'm not looking at the exact statement right now, they're acknowledging that there's elites from Iran who have been stealing from their country and easily hiding that wealth here in Canada. So yet again, another obstacle on sanctions, and another acknowledgement of our role in the global illicit financial flow system. But on that lack of data transparency, we also did another study that I alluded to, and we released last week. And Adam, you're once again the author on this. This was the Canadian Corporate Data Transparency Index. Would you like to walk us through what you found, how you did the research, and what you found?
Yeah, absolutely. Yeah, I mean, my day job is as an investigative researcher. I do due diligence, litigation support, and asset tracing. And firsthand, I've seen, yes, the comments that Trudeau made at this Iranian rally are absolutely true. I've been hired on many occasions to look at to trace assets of corrupt Iranians and others who are now subject to sanctions. And, you know, to be honest, we have a heck of a time doing it because corporate data in Canada is such a patchwork and so piecemeal. So with that, I'll take you through the last study that we did, which launched last week, which I think it's in parallel to our discussions about beneficial ownership reform. that file has moved, by, I think, public policy perspectives, like very, very quickly. I get frustrated with the pace of change coming from the private sector. But 5 years ago, we were the only ones talking about beneficial ownership at TI Canada and the coalition partners. And now we have pledges to roll out a registry in the next year. So I think that's pretty remarkable. But beneficial ownership data is, it's one of the most important, I think I'd argue the most important data point for corporate information, but it's not the only one. And so this seemed like a very appropriate time to look at Canadian company data more holistically, because it's not the only, ownership isn't the only data point that's relevant to deterring financial crime. We have directors of companies, as I'll get into later, using addresses and other data points to investigate and to do risk assessments is really valuable. And up until this point, no one had done a countrywide assessment in Canada of the corporate registries to assess kind of what data is available and how we can access it. So with that, I will share my screen. Let's see. Share screen. Okay. So with that, the Canadian Company Data Transparency Index, which is a bit of a mouthful, was born. And let's see, how do we, there we are. Okay, so many of you will be familiar with Open Corporates. They're a nonprofit that advocates for more transparent company data, and they make it freely available to the public. They've got a great website database that I use most days, which scrapes and makes available corporate data from jurisdictions around the world. They're actually very weak on Canada because of the state of our registry system. So the Open Corporates organization, they've come out a number of years ago with this Open Company Data Index, and that aims to assess every jurisdiction in the world on the openness of their company data. And so that was the inspiration for this project for us. We felt like the Open Corporates Index didn't get into sufficient detail at the provincial level and the territorial level in Canada. And the criteria that they use focuses really heavily on the openness of the data rather than the content. So rather than what the data is telling us, their metric, their assessment metric, is up on the screen here. 20% of the weighting is for if there is online data at all, and if it's free, or if there's a charge for search. 30% is for a fully open license. In other words, that there's no usage restrictions on the data. So someone like Open Corporates can scrape that data or use an API or a bulk download, and then make it available and analyze it as they see fit. The third, which is another 20%, is whether the data is available as an API or a bulk download, and if that's for free. And then the fourth is around the content. So are directors, shareholders, and annual accounts disclosed for companies in a certain jurisdiction? So half the points in their metric are linked to having a fully open API or a bulk download. It doesn't include any metrics for data quality. For instance, like whether a registry does independent verification. And the only specific data points that registries are evaluated on are directors, shareholders, and annual accounts. So that doesn't take into account beneficial ownership data. It doesn't take into account other information like addresses or historical data related to companies. So we adapted that metric and devised one that gave a bit more emphasis to data quality and depth of data. So this is our metric. We ended up ranking it out of 400 because there were a whole bunch of data points that we assessed each registry on, but then divided by 4, so we got a score out of 100. 20% was around accessibility. So are there search fees? Do you need to have a subscription? And so are there obstacles in place to accessing the data? 27.5% was around searchability. So how flexible are the search functions on the registry platform? And is there an API or a bulk download available? The third area was around data quality. So how reliable is the data? Is it independently verified? Are there quality control checks like drop-down menus or autocomplete address fields and prompts for people registering companies to confirm that the data they're inputting is accurate? And then the last area was around data depth. So what fields are published, what data fields are published? Do past directors remain listed and searchable? Are residential addresses provided for directors or shareholders? Are shareholders even listed? And so that was the basis on which we assessed all of the 14 registries in Canada. So we went about the research using a mix of open source online research, going through the process of setting up companies when we were testing data quality and what checks are in place for verifying data. And then where we had some blanks to fill in, we reached out to registry staff and got the information directly from them. So you probably won't be surprised to hear that the results are pretty poor across the board in Canada. These are the kind of headline findings. Data at Canadian corporate registries is very tightly controlled. The federal registry is the only one that has an open license. Most registries require registration, so setting up an account, although it's free. And most charge search fees, and those search fees can be anywhere from a few dollars to tens of dollars for filings. It's pretty common to have a $10 per filing fee, which means if you're actually looking at a company and trying to map out its history and it's been around for a while, you can quickly get up into the hundreds of dollars just for researching one company. Search functions are extremely limited. All of the registry platforms only allow for search by company name or company number. The federal registry has this API available. So through third-party sites like Open Corporates, you can scrutinize the data using other data points. So Open Corporates allows us to search by individual name if they're a director, or even by address. Data quality is very poor. So none of the registries check IDs of people setting up companies. Most of the registries don't collect shareholder data still. That's left with the companies themselves, who need to maintain securities registers, but they don't file that information. And still none of them collect beneficial ownership data. And that's changing, but we were assessing this at state of play this spring and summer. So none of the registries fared very well on that category. So the incorporation process essentially works on an honors system, where you can input any information often address fields and other information, that data fields that could be quality controlled, say addresses by linking up with Canada Post, for instance. Most registries don't do that. So it's free text inputs. And then lastly, very limited data is collected. So, and even less is made public. As I said, most registries don't collect shareholder data or beneficial ownership data. Financial information isn't disclosed for companies in any jurisdiction. And most registries don't require residential addresses for directors or for shareholders. So here's an infographic full of red and orange, which shows us how each of the 14 jurisdictions are performing now. Only the federal registry eked out a passing grade with 52.5 out of 100. That was largely due to their API and the open license. The others all fall between 6.25 and 37.5 out of 100. So there's a lot of room for improvement there. Yeah, and I think just to close out, I think our business registries, it's important to bear in mind that they weren't designed as a risk management tool. They were intended as repositories for company documents. You register a company, you file annually. They don't pay attention to what's being filed, essentially, as long as companies are in good standing with their filings. But that model's pretty outdated now, and we've seen time and time again that companies are misused for financial crime. And so we should be moving to a more proactive type of business registry, one that's got quality controls, that collects information on people behind the entities that are registered with them, and that makes that data available for analysis by not just law enforcement and regulators, but by people in the private sector, by journalists, by civil society. And I think as we move ahead with beneficial ownership reform, this is a perfect time to modernize those registries alongside it. Thank you.
Fantastic. Thank you, Adam, for that presentation on the report. And I've put the link to that report into the chat for anybody who wants to download and read it. A lot of great analysis went into that. Before we get into the technicals and kind of follow up on what needs to be adopted, a couple of comments from the audience. As we said, and I asked you, Sasha, what is the BC government's reaction to the Cullen Commission, a little bit the federal government's, but I think as we've alluded, or we've mentioned, this is a national issue and we need all 14 jurisdictions involved in this. This just can't be the federal government. So have you heard, is there anything beyond just what the BC government's reaction is to the Cullen Commission? Anything else to report on any other provinces? You said that most provinces are in a kind of wait and see pattern with the federal government. Anything else you can share with us?
For sure. Thanks for that, James. Yeah, absolutely. The Quebec government in 2020 announced that it's going ahead with its own provincial beneficial ownership registry, and it's going to be free to access. At the same time, there are some provinces, for instance, who are waiting on the federal government, but in Ontario, Ontario has just completed phase 1 of the the beneficial ownership agreement back in 2017, and it is going to be carefully monitoring the federal government. I think there was a question in the chat about the announcement of the U.S. Beneficial ownership registry and information standards. From what we've heard from the federal government inside the Department of Finance, is that the model is to emulate the UK PSC registry. So while the the US has gone ahead with a private registry, I think Canada will also have conversations with our friends down south and take stock of perhaps what data fields are being disclosed. But the aim is to implement a publicly accessible registry that's free of cost and with verified data.
Adam, any additional thoughts from yourself as to any other jurisdictions' reactions to the Cullen Commission?
It's not something I've been following closely. Other jurisdictions' responses. I think there's a comment about the perceived failure of the UK's corporate registry, and I think the Brits are following things closely. They're having parliamentary hearings now, and are slated to have some pretty major reforms to Companies House. So that applies to both the beneficial ownership registry and company data across the board. And it has, the perceptions that it's been a failure, I think, are justified. That thus far, the barriers to registering a company are so low in terms of cost and in terms of having other eyes on that data to the verification piece, that we've seen dead people registering companies, people all dotted all over the world with no idea that companies are being registered in their names. It's a huge problem, one that is being kind of flagged daily by people. I think chiefly among them Graham Barrow, who's an AML consultant and researcher. But the fact that the UK has an open registry and that data is shared in real time and that it can be analyzed in any way goes to show that can be a very powerful check on quality of companies. So, Graham, for instance, has a risk analysis tool, which I think is shared with financial institutions and others, where suspicious patterns of company registrations are flagged. And it can be data points that are so disparate that you would never pick it up on your own, but their tool picks it up if there are companies registered in the same neighborhood with similar kind of esoteric registered business activities, or people with similarly spelled names, where it's an intentional typo to confuse people. And if you're looking at looking at these companies one by one, that would be lost. But the fact that there's this open, that it's open data, allows people to analyze it. And so the UK is also belatedly coming around to the fact that their companies have been abused for ages. And so they're looking at independent verification, charging a bit more for companies when they're being registered, and other tweaks that can be made. Tweaks might be underselling it. I think it needs to be kind of wholesale reforms, adding more budget and staff to Companies House so that they can actually, investigate matters. So, to write the UK off as a failure, I think is premature. I think they're kind of leading in some ways and tripping up as they go, because they're the first mover, and we have a lot to learn from that.
Right. Sasha, you had a follow-up point?
For sure. I think this is just building on Adam's comments, particularly around registering companies, and this speaks to one of, I think, Canada's I would say like Canada's shifting mentality about beneficial ownership transparency and the value of corporate transparency more broadly. There was this notion that being able to incorporate a company very quickly without any restrictions or very little friction will enhance economic competitiveness, and that is very true, right? Like in many, like, you know, to have a competitive economy, especially within a G7 economy, you must be able to incorporate a business quite smoothly, and it should be a very easy path to do so. However, that's not necessarily correlated with inward foreign direct investment, and that concern was one of the was part of I would say is one of the reasons why Canada was so hesitant in moving forward with beneficial ownership transparency, and it's that it would create an added restriction that could compromise Canada's economic competitiveness. Canada in the past has used the World Bank's Doing Business Index to showcase sort of the country's ability to do business with ease. In previous reports, you know, Canada scored quite high on that index. I think it was fourth in the world at one point in being able to open a business. It turned out that the World Bank ended up scrapping that entire index due to corruption allegations, where certain countries were lobbying the index, the department that put together the index and would establish scores, and they recognized that simply having an open business an open sort of business infrastructure where it's really easy to incorporate without any checks and balances isn't necessarily good for business, and it's not good for the integrity of an economy, especially in today's 21st century economy, where international capital flows are large in volume and have high velocity. So just wanted to provide some context there.
Right. And I would say, kind of going back to this point about, and both yourself and Adam are alluding to kind of global trends, just taking it back domestically amongst the provinces. I would just kind of chime in that, you know, as Sasha said, it's a kind of a wait and see process from a lot of the provinces, because this hasn't really come up on their radar. It's still seen as a national issue, except for Quebec and British Columbia, because scandal creates necessity. So Quebec has moved forward faster than even the federal government, because they've gone through being raked through the coals by Charbonneau Commission, and they've seen the necessity of addressing beneficial ownership, transparency, as a key step to fight corruption, money laundering. Of course, BC now going through the Cullen Commission. And we unfortunately face a regionalization of priorities in Canada on issues like these that are a national issue. And majority, of course, Ontario. You know, this is seen as things happening far away, but our opacity report that came out in 2019 was a risk assessment of potential money laundering in the Greater Toronto Area. I'm sure a number of you on the call who are experts in this field know full well of the money laundering risks right here in Toronto, given our converging points of global economies. And so Ontario government really needs to not just say we continue to take this seriously, but work harmoniously. There's other provinces that maybe are taking a slightly even slower step, who should be taking a faster step. So say New Brunswick was always considered a bit of a hotspot, especially because of its lack of requirement of a director to actually live in Canada. And it wasn't until 2 summers ago now, time's kind of melting between itself, that the CBC raked New Brunswick through the coals in that story about ghost illegal fit. It's tough to get a mouthful. Illegal fishing by ghost trolleys off the coast of West Africa that were insured by you know, shell companies linked to New Brunswick and then linked to Alberta again. So that came out in the headlines, and New Brunswick quickly moved ahead with catching up with the first phase beneficial ownership transparency measures to mirror the federal government. Alberta was possibly still is the last holdout on that first phase. When the Cullen Commission issued their research on the impact of money laundering or the impact of money laundering on real estate, I think, or even the provincial economy, Alberta, because of the modeling that was used, Alberta had one of the highest threat assessments, and I think kind of quickly dismissed it as an issue. And I know that iPolitics recently canvassed provinces to see what their standing is on following government initiative on beneficial ownership transparency. And Alberta is still the last province to initiate reforms based on amendments that were made to the Canada Business Corporations Act. So I'll just say that in our study earlier this year, Snowwashing Inc., Adam did find, and this is public documentation as part of the Cullen Commission open reports, an Alberta limited partnership was involved in the Azerbaijan Euro laundromat that was involved in Azerbaijani officials funneling money to Western European officials and journalists to pay them to say nice things about the Azerbaijani government. So this is affecting the whole country, and nobody can kind of sit behind. That's at a national level. Adam, did you have something to chime in?
Yeah, a couple of, I think you touched on a few things that I was going to speak to. One is that when I was doing the research for the Canadian Company Transparency Index, overall, the registry staff were quite cooperative to responding to questions that I had. The exception was Alberta, where I was referred to the legislation and told to read it myself and come to my own conclusions, that no help would be provided. And I think that's indicative of the Albertan government's kind of overall approach to beneficial ownership transparency and transparency full stop. I do a lot of investigative work there, and there are obstacles to accessing data across the board in Alberta, in the courts, with Albertan companies. They operate a very different system. And to my understanding, there's a couple of common justifications for that. One is ease of doing business, which I think is a red herring, because it's not easy to register companies in Canada compared with other jurisdictions. The Canadian registries are, for the most part, quite outdated, though they're beginning to modernize now. Alberta, for instance, you need to go through a registered agent and have them do it for you. I believe most of them require you to actually send somebody in Alberta rather than doing it online. So the process of setting up a company isn't that easy. We just have registries that are quite limited in what they share and what they collect, and the quality of data is very poor. So I don't buy the argument that it's about ease of doing business in registering companies. Right. The other major, I think, point of contention is around privacy. And that's, I've seen a comment in the Q&A about that. And that is a legitimate concern for a lot of people, right? Putting their home addresses on corporate records, which then become public, or their full dates of birth. And I think in the course of the last several years, as the coalition's been advocating for beneficial ownership reform, I feel like we've kind of struck quite a good balance around privacy, certain fields not being disclosed with everyone, being made available to being collected by the registries, and then being made available to law enforcement and certain regulatory bodies, CRA, for instance. But we're a long way from that now. Most jurisdictions allow people to sign up to a post office box or use a law firm's address. And so there isn't even the collection of personal information there. Dates of birth, that helps when you have somebody with a common name. But an alternative to that is around unique identifiers. And I think that's something that's being explored as well, where it may not reveal personal data, but it allows people who are researching to be sure that company A, B, and C are linked to one person by that name, and D, E, and F are linked to somebody else. I think another point around privacy is that often the case is made for making this data available only to law enforcement and to certain government bodies. But the fact is that enforcement is quite poor and has been historically and will continue to be because of resourcing issues. And there is a huge kind of body of stakeholders out there using civil law in order to fight financial crime. And by that could include the banks and their due diligence processes and compliance. It can include private prosecutions. It can include shareholder lawsuits and lawyers and investigators like myself who are being hired to trace assets when a fraud has taken place or look at conflicts of interest. And by limiting that data to law enforcement and regulators alone, it really hamstrings all of those other stakeholders who do really have a part to play in fighting financial crime.
Great, thanks, Adam. Before we get into, and you've alluded to the technicals of what we want, Sasha, do you have another follow-up before we get into the technicals of how a registry would work?
Oh, you know what? I was just going to jump into that. So,
okay. We'll get into the technicals in just a second. I just want to cover quickly global trends and maybe one or two questions from the audience. And if Myra was here, we're going to ask her to talk about global trends that are going on, just because we've been talking about the UK. I'd want to flag that it's not just the UK, it's not just Canada we're talking about. There are, about 100 countries right now that have committed to a publicly accessible beneficial ownership registry. And this is thanks to a handful of initiatives, including the EU's Anti-Money Laundering Directive 5. Different EU countries have set up a public registry to different degrees. France just recently made their registry fully publicly accessible. Germany, I saw in comments recently, as the host of the G7, is realizing that their registration and cost barriers should maybe be brought down. So hopefully we'll see Germany with a publicly accessible registry. There's the Extractive Industries Transparency Initiative, which is calling on all of its 54 members to have beneficial ownership data on gas and mineral licenses be publicly available. They recommend the best way to do that is via registry. And then there is the Open Government Partnership, which is calling for its members to also have publicly available registries, of which a number are signing up. And then, of course, there's the Financial Action Task Force, which recently updated Recommendation 24 around beneficial ownership registries, where it used to be a note in the recommendations on biotransparency that you could have a registry, but it wasn't really a requirement. They've now moved that to one of 3 requirements to have. They don't say publicly accessible, recognizing that not every jurisdiction is safe, but this is the trend and the way to go. So Canada, at least has to get something going. I think it's time that we do turn to the technicals about what is it we actually want. Adam spoke about the data fields, but we've been getting questions about digital ID. Obviously, this is a hurdle for the UK in their registry. We're specifically talking about a federal registry. We're talking about 14 jurisdictions, which even some of our international peers have not always understood. We've had American peers that we work with and Europeans say, why can't the federal government just go ahead and do this? So Sasha, why don't you walk us through what is it a Canadian federal registry would look like, and what are the components we're asking for in this, building off what Adam talked about with data points.
For sure. Thanks so much. And yeah, and James, on the figure worldwide on public registries is 106 country commitments for publicly accessible registries. And I just want to emphasize how significant that number is, because about 5 years ago, there was maybe, we're talking like low double digits in terms of commitments to public registries. And now it's 106. The fact that there's 106 countries doing this really shifts the balance towards public registry implementation. And so how would Canada do this? And I think it speaks to one of the questions I think that was asked, whether the federal government's plan is realistic or not. And yes, it is realistic, and it's doable. It just requires a very clear path forward and the will and the ambition to execute completely. So our approach to a public registry, a public interoperable registry, is for the federal government to build, house, and keep all the beneficial ownership information in a central registry. This allows all the expertise to live at the federal government. It requires the federal government to fund the registry and build out the IT architecture. And then what can happen is, just like the 2017 agreement to strengthen beneficial ownership transparency, we would like Canada's current finance minister, Minister Chrystia Freeland, to strike an agreement with all provinces and territories for a pan-Canadian registry. And what that would entail is that all provinces and territories would amend their own provincial business statutes to allow provincial entities to flow their beneficial information into that central registry managed by the federal government. In exchange, the provinces wouldn't have to build separate beneficial ownership registries, and they could be granted, all provincial competent authorities and regulators can be granted access to the back end of the registry for any due diligence or investigative purpose. And we think that model, a centralized approach, is the quickest and most effective way to ensure coverage for the entire country. I think the federal government has foresaw that approach, and to create a little bit of flexibility in their budget 2022 commitment, they've noted that they want to work on this with willing provinces and territories. As we know, in Canada, being a federated jurisdiction, it's always incredibly difficult to get all provinces and territories on board with a federal initiative in one shot. We know that from similar pieces of legislation that have been going around. We know that there's been challenges, for instance, with the $10 a day childcare, the carbon tax. And so likely we're going to get a whole bunch of provinces who are going to say, yes, they want to join up with the federal government, and we expect the smaller provinces to be enthusiastic supporters, simply because they just might not have the resources to create their own beneficial ownership registry. There's going to be some leaders who've already done a lot of thinking on beneficial ownership transparency, and there'll be some laggards. There will be some provinces who will say, you know what, we just want to wait and see how the registry evolves before joining. If there are holdout provinces, I'm speaking for myself here, but I expect that they will end up joining within, let's say within 5 years of an implemented registry. And here's why. All business industries within that holdout province will start petitioning the government to join, because they would need access to that registry to carry out due diligence on their own provincial clients. And that's gonna be a huge demand for data. At the same time, those holdout provinces will start to see a flurry of very suspicious incorporations, and there'll be increased international scrutiny on that province as a whole. And the combination of developing a reputation as the new Delaware or Canada's secrecy holdout, in conjunction with pressure from industry to have access to key beneficial ownership information, I think will eventually persuade these holdout provinces to join on board in a pan-Canadian initiative.
Great, thanks. On having this registry, a big thing that obviously comes in. I was at ACAM's Canada conference this week, and from industry side, and I think even from a handful of our panelists and everyone's saying is, crooks don't put in real data. So what's the point, and how do we know the data we're using is any good? How are we going to verify data? Any thoughts on that, Sasha?
For sure. So the first step with data verification is there should be a requirement for companies to hold copies of the IDs of the beneficial owners at the firm level, because at some point they are going to have to make sure that the beneficial owner is saying who they claim to be. And then once the federal registry is scrutinizing beneficial ownership information, they can get in touch with the firm to verify some of this ID. There are technologies that exist, particularly on digital ID verification, and these are technologies that are being used by Canada's financial industry and can be rolled out. I think the first step is to ensure that companies do have a requirement to hold physical copies internally, because companies do have to, companies are already required to hold beneficial ownership information, and there should also be a responsibility to ensure that this information is accurate. Now, in terms of penalties, who's ultimately responsible? If a company is holding this information in good faith, then the penalty should be heavily weighted on the beneficial owner. Because why should a company be responsible if a beneficial owner is falsely declaring their identity? And this is one way in which we can reward good corporate behavior.
Great, thanks, Sasha. Adam, any thoughts on ID processes? I mean, you were heavily alluding to this is a necessity for a publicly accessible registry, is to have extra eyes on the data.
I kind of stop where the real technical discussions around digital identities and verification processes begin. But I think the fact that data needs to be independently verified, that it needs to include, I believe, until I see something else that convinces me otherwise as far as digital IDs, that the real people behind companies have their government IDs reviewed, say by the registry would be one model, to make sure that they are who they say they are. And there are processes. Everyone here has probably held their passport up and in front of a webcam before and had that, gone through that verification process or something similar. But I think fundamentally there has to be that independent verification so that we know that the data is that it's reliable. And until it isn't, there's still a value in requiring that information from people setting up companies, because if there are adequate penalties in place and it's being enforced as it should be, that creates an offense, and there's the opportunity there to go after people for false declarations, for materially kind of intentionally false declarations. We haven't seen much of that. The UK kind of got off on the wrong foot by chasing after somebody who had in jest set up a company naming I don't know if it was a parliamentarian or a peer, whoever it was who had responsibility for that file in government, and they went after that individual rather than the hundreds or thousands of others that they could have. So yes, it's all going to come down to enforcement.
Sasha, follow up?
For sure. And just as follow up, Canada doesn't have to do this alone. I repeat, Canada does not have to do this alone. There's partners now that Canada can work with. They can work with the UK, as they've already committed to including verification mechanisms as part of the PSC registry. And the other thing is that while all this talk about, verification and enforcement and, putting together, developing the architecture of the registry, while that all sounds really complicated, it can be sequenced in a way. It's not like Canada's not going to get everything right on its first go and have it neatly rolled out and implemented. I think that's just unrealistic in any major initiative. There's going to be phases. There's going to be a series of regulatory hearings. There's going to be review of the current data and how to improve the regime. And so in terms of first steps and recommendations for perhaps effectively lobbying or improving, and moving this process forward, the first step is to continue to put pressure on Minister Champagne's office. So he's the Minister for Innovation, Science and Economic Development, for Canada to strike a pan-Canadian agreement for a central registry with provinces and territories, and to ensure that verification mechanisms are built in. As the registry is rolled out, I expect there's going to be some rudimentary verification mechanisms, I think, namely requiring corporations to hold this information internally, and for the registrar to carry out audits, let's say, as a first step. And as the next step, I think that's when we're going to see the adoption of the right digital ID technology, and then for companies to simply send this information to the registry, and the registry system simply verifies the ID at the point of registration or at the point of updating the beneficial ownership information. So that's just like one model, but we're never going to get it right in one mouthful. It's going to be a series of steps, and I think the most mission critical right now is to ensure that the provinces and territories are on board with a harmonized standard that is managed by the federal government. And I think I saw one quick question about limited partnerships. Absolutely. All partnerships, like general partnerships, limited liability partnerships, should be included as part of this first take at a corporate beneficial ownership registry.
Great. And I think on this point about will the registry get everything right on the first go and how valid is the data? Again, at an industry conference this past 2 weeks, I had to say I was a little bristled at the skepticism from industry. And I think it really comes down to this issue of liability, that the financial institutions have so far been liable with doing the beneficial ownership information review, and now designated non-financial businesses and professions, DNFPBs, like real estate agents and accountants, not lawyers, now need to do this beneficial ownership review. So it surprises me that there's so much concern about the registry, and I suppose it comes down to who ultimately is liable for the data. Is it industry or the government? And I was very happy to hear, even though it took a little bit, a few times for him to say the answer directly, but for a representative from Finance Canada to say that the federal government is indeed the gatekeeper of verifying data, e.g., liability at the end of the day is on government, and therefore this is a tool for industry to use. There's hopefully going to be support from industry to verify the data, and I think the example was given that with the land ownership registry in BC, lawyers are asking, well, can my client use the land registry there for any of their forms, and asking to FinTrack, with FinTrack not giving a concrete reply saying we accept information from regulated entities, and this goes to the provincial federal divide, that they're going to have to harmonize language and harmonize any legislation so that data going between the jurisdictions is useful for industry. But that was, I think, a lot of it was coming from large corporation. We have a question in here about small, medium-sized enterprises. And of course, we've heard the concerns from government and industry about what about the quote unquote mom and pop shops, the scare of the government of a million little old ladies who can run a business but apparently not enter in beneficial ownership information, flooding them with calls. Any thoughts on the usefulness of this registry to SMEs, or the quote unquote burden to SMEs by this registry? Either Sasha or Adam, if you want to take it away.
I turn on my mic for that.
Go. I know you're just riled for it. Go ahead, Sasha.
For sure, I'll keep my comments brief. So I think we have to remember the following with small, medium enterprises. So when we look at the composition of businesses across Canada, yes, about 90% of businesses are small, medium enterprises. However, within those small, medium enterprises, they have very much simpler ownership and control structures in comparison to medium and large Canadian corporations. A lot of them are sole proprietorships. Others have general partners. So there's only 1 to 2 beneficial owners, and let's say a bookkeeper or a lawyer. All we're talking about is simply emulating the information that is already required in a conventional business registry. So the name, a partial date of birth, a service address, to what extent to what extent you control your company, what is your ownership stake in the company, and just keeping that standard record at the firm level, and then uploading this information into a registry. We've seen how much this costs in the UK, for instance, and in year 1, small and medium enterprises, for small and medium enterprises, it costs them about £50 in year 1. In year 2, the cost of uploading this information and updating beneficial ownership information was about £4. So it's the burden, I think, I don't think it's that big for small and medium enterprises. There's a lot of benefits to this information as well. Rates of fraud are up for both consumers and for businesses. And there's been a lot of phishing scams, particularly targeting small businesses, where contractors try to solicit businesses and offer them counterfeit goods, or goods that just simply are ineffective. And the beneficial ownership registry is one tool that a business would be able to access for free to verify, to carry out due diligence on a potential supplier. So yeah, I just think that sometimes with this, we want to safeguard small medium enterprises and allow them to operate and to ensure that burden is minimal. But I don't think that this registry is going to pose a significant burden for SMEs, and evidence from the UK also supports this.
Great. I mean, Adam, you're an independent contractor. Are you afraid of the registry and all the hurdles that you have to go through to register?
Maybe I should be, but not from that angle, from the nature of my business as a due diligence firm and an investigator. So my clients tend not to be SMEs. Private investigators, lawyers, they're expensive. SMEs are reluctant in general to pay the cost for external parties to do due diligence. So they tend not to do that due diligence now. And if we imagine kind of a reality where we have a functioning registry where the data is of a high quality and it's accessible to people, I think we'd see a lot more SMEs doing their own due diligence. Where I do get SMEs approaching our firm is on the back end when they've been defrauded, when there's a lawsuit, when the proverbial shit has hit the fan, and that that can be very expensive. And I think this should be seen as an opportunity for SMEs to be able to do some due diligence themselves without paying other contractors, and to protect their businesses. And the cost of compliance should be pretty low for most of them.
Sasha, follow?
Yeah, just a quick follow-up. And just to iterate to the audience, we are not, as a coalition, our recommendation was not to have all personally identifiable information publicly accessible. We've been advocating for a two-tiered system where sufficient information is in the public realm, and personally identifiable information that is sensitive should be private and only available to competent authorities and law enforcement. In addition, we just note that some individuals might be at risk of targeting or harassment, and they might happen to work from home, let's say, and their home address is their service address. In those very unique circumstances, we've recommended the federal government that there can be an opt-out provision where that individual can apply to the registrar and state their circumstances, and their information can be omitted from the registrar itself. And we just acknowledge that certain people in society do need extra protection, and we're very sensitive to that.
Great. We have scheduled 2 hours, but I know Myra isn't here, and that we're accommodating for 3 people, and obviously the 3 of us can talk about this forever. But I'm also cognizant that people have busy days, and we might. I think we've covered a number of topics, so we might take the opportunity to wrap up here. We've covered most of the questions. I want to acknowledge somebody who asked the question, and maybe Adam, because you helped conduct research with the Cullen Commission, you can say yay or nay to this. I don't recall seeing this as an example, but did the Cullen Commission look at Estonia's examples of digital ID?
I wasn't involved in that aspect. So it's possible. I think they looked at a number of different models and spoke with many stakeholders, but I wasn't involved on that side.
Okay, I just wanted to make sure we got that one, as it was posted in the chat and in the questions. So at this point, Canada, national crisis level, we've been dragged through the coals by the FATF. Transparency International has dragged us through the coals. We have a commitment by a finance minister that this is on her personal agenda. We have been unable to track sanctions effectively in Canada. We have one provincial commission, but we're not sure about the ripple effects. Maybe just some parting thoughts on how we see the future playing out between now and the end of 2023, from a national level to even a global level. Sasha, do you have thoughts where we go? We even had the question, what can we, I guess the collective we on this call, all do to keep this going?
For sure. Thanks so much, James. So like the signal that we've received from the federal government is that they are on track with work on the federal beneficial ownership registry, and they are also under immense pressure because of the global circumstances that we've discussed. For instance, with the Iranian sanctions that have been implemented, the same question popped up in press conference. How do we know that entities are not all owned or controlled by individuals in the Iranian regime? And Minister Freeland stepped up and she said, we're going to implement a beneficial ownership registry to help us with this. And so I think for the first time that really signals a recognition from the federal government that this tool is of importance for Canada's national security. In terms of predictions, I think the federal government is going to roll out this registry. We're going to continue to push to ensure that there is an additional pan-Canadian agreement between the federal government and all the provinces. As for what advocates can do, they should certainly send a letter or contact Mr. Champagne's office, who's the Minister for Innovation, Science and Economic Development Canada, and also contact the Finance Minister in Ontario and encourage them to be a supporter of a pan-Canadian initiative. That's the most useful way to move this forward, because we're still at the stage where we just need support at the provincial level for this kind of a framework, and then for the federal government to deliver on that.
Great, thanks, Sasha. Adam, thoughts? Parting thoughts?
Yeah, I'd echo what Sasha has said. I think it's important to bear in mind that there's going to be a displacement effect, where as Canada moves forward with greater beneficial ownership transparency and hopefully corporate data transparency across the board. And I think this is true of kind of getting our collective act together as far as financial crime, the fight against financial crime and anti-money laundering efforts. The people who abuse the system are going to move elsewhere. That might be to other jurisdictions, like other countries. It might be to other provinces and territories within Canada, if we don't have a unified approach and kind of raise the standards across the board here. And I think that would be really unfortunate, because despite some resistance by certain provinces, I don't think any of those provinces wants to be a hotbed for criminal activity. And that is a very real potential consequence of not coming along with the others on this reform. I also think we've touched on the beneficial ownership registry, and then this latest this report of ours around corporate data transparency more generally. And this is a great opportunity to modernize registries across the board and to do some navel gazing as far as what data is collected, how it's collected, and how it's shared. Most of that data is collected at the company level. It's just not shared with the registry, and then it's not made public. So it wouldn't be that taxing to make some changes in that area in order to get more data out there. And I think the data quality piece is a bit more involved, but it's an absolute essential, and we need to tackle that, even though it's going to come with some cost and be a bit trickier to roll out. And then lastly, on the advocacy piece, I think you just need to be loud, right? And continue to press policymakers to raise these issues in conversation with other people at work and in your personal life. It's not an area that a lot of people are tuned into, but I think there's a pretty compelling case that can be made for why they should care. These changes don't necessarily move very quickly, and at the same time they can move very quickly all at once when there's sufficient support and when external circumstances change, as it has with the invasion of Ukraine and the Canadian policy towards Iran. So I think everyone here has an interest in this area, and just encourage you all to be vocal about it.
Great words. Talk to people you know, including conversations. It's Halloween. As trick-or-treaters come to your door, tell the kids about beneficial ownership transparency. I see this as a perfect opportunity. On my own predictions, I'd say, we always get the comment, well, why Canada? Why should we have beneficial ownership transparency? The crooks will just move somewhere else. yes, exactly as Adam said, even within the country. But as Sasha pointed out, there's 106 countries moving towards beneficial ownership data transparency, and Canada can't be a laggard because we don't want to be the secrecy jurisdiction. But if we also want to combat this, we have to show that we have a leg to stand on. And this is why Canada must do this. The more and more, if we want to call it democratic rule of law countries that have these registries, the less places there are for the crooks to hide their money. Because remember, they're taking the money away from many of the locations where a government could just go easily snatch their funds. Hold your comments on the Emergency Measures Act. That's a whole other conversation that we can have another time. But the trend is going in this direction. Canada needs to be part of it. And as much as the comments in the Q&A section in the chat alluded to the UK and its fallings, and I heard it earlier this week in an industry conference, we have to recognize that the UK has seen its problems and is holding hearings currently to fix this. Other EU countries have seen the UK's problems. Even the UK and all the conferences we've had with UK reps will instantly say, we are not the gold standard, we are the guinea pig. So I think this pointing to the UK is a red herring. We need to learn, as Sasha said, we might not get everything right in the first go, but we need to keep it reforming and have it on the Canadian government's books to maybe have an even quicker period of reconciliation for the registry. We heard from the BC government that they might not fix the land registry for 5 years. We certainly hope that the government, as it comes in place in BC, fast tracks fixing that. So I'd see that as some points for hope in the way forward. And if you're interested in continuing the conversation, of course, there's more than just the registry, as we constantly say. It's, the registry is one tool, a very important tool. I know Joe has alluded to the next conversation in the anti-corruption law program will be on unexplained wealth orders. But there's also a lot of hype around the idea of a financial crime agency in Canada. And what will this do? We talked about resources, and I am going to abuse my position. This is not corruption. This is just overpowering. As moderator, to advertise the TI Canada Day of Dialogue is coming up on November 17th. We will be discussing the Financial Crime Agency along with a number of other topics. Coming up on November 17th here in Toronto, hosted by Deloitte, we'll be discussing the establishment of a Canadian Financial Crime Agency, fighting corruption at the municipal level. We'll have the Inspector General of Montreal, former Toronto Mayor David Miller, part of that conversation, addressing corruption, anti-corruption in Canada's justice sector, which will also highlight on issues about capacity, rules that are maybe too stringent or need to be re-examined in Canada to fight white-collar crime, and addressing corruption through ESG standards. We'll have Marcus Kolga as our keynote speaker to talk to us about addressing sanctions and corruption in Russia. And as well, we'll be presenting the second TI Canada Canadian Integrity Award. The selection committee has picked a winner of that. Adam is part of the nominations committee, has helped out in deliberations. Really looking forward to that. And as always with the TI Canada Day of Dialogue, part of the great part of it is the conversations that we have amongst the crowd who's there, the networking opportunities that are there, and the dialogue, just like we've had in the chat section and the Q&A between the panel and the audience. So please do sign up for the TI Canada Day of Dialogue on November 17th. Today is the last day for early bird tickets. We hope to see you there. Hope to see you at the next anti-corruption law program webinar, and stay safe, everyone. Get your flu vaccinations, your bivariant COVID vaccinations, and we hope to see you again. Thank you, Sasha. Thank you, Adam. Thank you, Joe, for joining us. Myra, we wish you well. Hope you recover soon, and have a great rest of the day, everybody. Thank you.